There is so much going on this morning, but of course, we start with that shocking news from the Supreme Court, although some may say this could be the Supreme Court making sure it's doing its due diligence, given the gravity of everything that is at stake.
Certainly not the end of the story here, but a delay at the very least. The Supreme Court has agreed now to consider former President Trump's claim of presidential immunity in his federal election interference case. The conservative court's decision to hear the case will further delay a potential trial. The High Court has scheduled arguments for April 22nd, and a final ruling might not come until months later at the end of the term in June. If the court rules in favor of Trump, the special counsel's charges would be dismissed. The U.S. Court of Appeals unanimously ruled Trump does not have absolute immunity. But if the Supreme Court does affirm that, the delay still would push the start of the trial probably into the fall. Let's bring in former litigator and MSNBC legal correspondent Lisa Rubin and former U.S. attorney and MSNBC legal analyst Joyce Vance. Good morning to you both. So, Lisa, let's pause for a moment. I think this was shocking news to a lot of people, but let's talk about what this decision is and what it is not. It does not mean that the Supreme Court agrees that Donald Trump has presidential immunity. It means that they're going to hear the case, possibly that he does have immunity, and at least knock this down into the fall.
That's right. And Willie, the way in which the order yesterday was phrased is also a little bit telling. The question that the Supreme Court has agreed to resolve is a narrow one. It's whether, and if so, to what extent a former president has immunity for his official acts or his official acts as alleged. And one of the things that's really, I think, concerning about the way that the question is presented is alleged according to whom? Because if you ask Jack Smith, the way that the indictment is framed, none of the acts for which they are trying to hold former President Trump criminally accountable were in fact official, that a president plays no official role in the administration of federal presidential elections. And so the way that this is phrased is slightly troubling, even for those who might push back and say, this is the Supreme Court trying to button up an important issue that is percolating in at least two federal courts right now and is likely to recur in the Georgia case should the Fulton County RICO case continue beyond this existing motion about Fani Willis's disqualification.
Joyce Vance, a lot of concern and reaction to this. What's going on? Another delay tactic. But when you look down the pike and you look at how this is going to be seen in history, I mean, I don't see a reality, maybe you can correct me, in which the Supreme Court doesn't agree with the decision that has already been made, that a president somehow has immunity and can have SEAL Team 6 take out people that he wants to take out. I don't think they're going to go that way. But in the history books, they will be able to show that every stone was unturned every step of the way in this. Having said that, there is such concern about losing time and this going beyond the election. What are your thoughts?
Right. So I think it's an interesting observation, Mika, and I'm reminded that Bill Barr, who was one of Donald Trump's attorney generals, used to say that history is written by the winners. And I think that's the concern here, whether the Supreme Court has given Trump such a big win by adding 2 more months of delay onto this case that it makes it more difficult for Donald Trump to be portrayed as the criminal that many people who have looked at this evidence believe he should be portrayed as. I agree that the Supreme Court is extremely unlikely to reach any conclusion other than Donald Trump specifically, and they don't need to talk about all presidents here. That's unnecessary. They can look at Donald Trump and say, this individual, this former president, is not entitled to any form of immunity for his effort to interfere with an election. They don't need to talk about all potential crimes a president could commit. They don't need to talk whether or not a president's official acts might be cloaked in immunity. For instance, when he's making time-pressured decisions on the battlefield, that's something that Jack Smith has argued in the past doesn't need to be a part of this case. But for the court to look at Donald Trump's conduct here and reach any conclusion other than the fact that he can be prosecuted in the criminal justice system would be tantamount to saying that presidents are in fact above the law, that Donald Trump is above the law. And that, not to be dramatic about it, would be the end of one of the most cherished principles of democracy, that no man is above the law.
No, I don't think you're being dramatic at all. That's what's at stake here. And Jonathan Lemire, you cannot separate this. Yes, it's a legal question from the politics. The idea for Donald Trump and his legal team has been to delay, delay, delay. If he can get himself reelected in November, he becomes president. He controls effectively the Justice Department. He can make all of this go away. And as you look at the calendar, the Supreme Court rulings come out in June, sometime in mid-June. A trial we're hearing may not start until September, October. I know Joyce is skeptical it could even get underway before the election begins. This does, in many ways, help Donald Trump's cause as he looks to have this stuff just go away.
Yeah, so many Democrats reached out to me yesterday. I was just like, I can't believe he's going to get away with it again. There's this sense of frustration that Trump always seems to escape, to slip the hook. A few things here. Yes, that's the legal analysis. And it's probably right in some ways. The Supreme Court should take the case, even if we do expect they will rule they agree with the lower court. But let's talk about the presidential campaign and the timelines here of the 4 cases. We know that the Georgia case has become a bit of a mess. There's a suggestion, and it's also sprawling to begin with. That one always is perceived to probably not start until 2025. The classified documents case in Mar-a-Lago, there's some real reasons for delay there because of the sensitive materials, but also Trump pulled a friendly judge who seems to be willing to go along with the delay tactics. This case now may not happen until the fall or perhaps after the election. If Trump wins, he can wave his hand and make his attorney general make this go away. So that just simply leaves the New York case, which is scheduled to start in a few weeks, but is perceived by most, Elise, as the weakest case, one that might not even carry prison time were he to be convicted. So I think when we come to the end of this, it's what Biden campaign aides have been saying all along. We can't bank on the courts to bail us out. It's becoming very clear that's the case. They're simply going to have to win this election in the campaign.
And that's the truth. And Jen Palmieri, our friend, was on your show earlier and said exactly that she has never thought that the defeat of Donald Trump is going to come in the courts. And I completely agree. And while I think, for many reasons, it's unfortunate that Trump always seems to escape justice, at the same time, we don't want our judges and our rule of law being dictated by a political timetable. And likely, I talked to a Supreme Court insider yesterday who told me that it seems likely that the Colorado ruling, that case, that Trump will win probably at the court. In this case, Trump will lose, and that very likely both could be almost unanimous, and the court could be pretty unified in these decisions. And so if that happens, it is a good show of strength for the rule of law in America, just that the process has gone through the steps.
Yeah, I think that's clearly right. So, Lisa, let's set aside the politics now and just go back to the legal merits. Walk us through what should we expect? They've agreed to hear this now in April. What does that look like? And then what sort of timeline should we anticipate for a decision? And if you will, if assuming Elise is right and that they rule against Trump in this case and the trial does proceed, Judge Chutkan has said she's going to give the parties time to prepare. What's your best guess as to when that could come to trial?
Well, let's start, John, with the math that's remaining. When Donald Trump's case was paused to allow for further consideration of the immunity issue, there were 88 days left to trial. Judge Chutkan has publicly committed herself to giving Donald Trump around 7 months to prepare for trial. So we have to assume that she takes that 88-day remainder fairly seriously. She has also said, including through a pre-questionnaire that went out to prospective jurors in the Washington area, that this is a trial that will take around 3 months. So you have to build into the calendar that 88 days plus 90 days to try the case if you think that this is going to happen before the election. And that's why folks like me are asking the Supreme Court, why didn't you write like you're running out of time? Because time is quickly elapsing here. There are folks who believe that the Supreme Court could rule quickly after the April 22nd oral argument. Our friend Neil Katyal, for example, is one who believes that the court will render a ruling by sometime in early May. On the other hand, if you believe that the court is likely to push this decision until the end of the term in June, which usually ends at the very end of June or July 1st, like our friend Judge Michael Luttig, then you're really in a crunch with respect to the calendar and if and when a trial can begin. There is also, finally, the question of Department of Justice policy. I've heard a number of folks on our air and other places say, well, wait a second, the Department of Justice prohibits taking steps in a case like this 60 to 90 days before an election. That's not my understanding of DOJ policy, which prohibits overt investigative steps, not the trying of a case. But more importantly, the Department of Justice won't be in control of when this case is tried. That will be up to Judge Tanya Chutkan if and when the case is returned to her. And in that instance, I believe that Judge Chutkan would proceed even if we are well into general election territory at that point, John.